Hello, how are you doing? Once again, I'm coming to you and we're going to talk about our collective or our master collective bargaining agreement. Today we're going to talk about Article 48. Article 48 is a very, very important article in the master agreement, and we're going to talk about official time. We're going to talk about that subject that should not be a subject. And let's have that conversation. Let's go through this video together. If you want to follow along with me, I'm on page 245 in the hard copy, and I'm not sure what page is going to be in the electronic version, but in the hard copy, I'm on page 245, okay? Now, Congress first put into law, I'm on Article 48. Article 48, labeled official time, and it's on the hard copy is on page 245. All right. First of all, Congress wrote into law that the federal unions will be granted official time in any time that's been deemed to be reasonable, necessary, and in the public's interest. Okay? And let's go through each of those subjects as we go through the master agreement. And we're going to talk about the agreement, we're going to talk about statutory law, and we're going to talk about what is necessary and what works in the public's best interest. Okay? And I'm going to try to shed some light on the official time and why it's so important to the bargaining unit. Okay? But Congress actually enshrined into law in 5 U.S.C. 7131, where it says that official time, it basically guarantees official time to union representatives to be able to exercise their statutory right, which has been enshrined in 5 U.S.C. 7102, which is the right of any member to join a union, help a union, represent a union, participate in a union, form and join a union. Those rights are guaranteed to you through federal statute. There is nothing a local agency can do or say to prevent you from exercising that statutory right. And that right, once again, is to form, join, help, represent, whatever it is you want to do that makes your heart feel good about a union. You have that federal statutory right to do so, and no one can take that right away from you. 5 U.S.C. 7102. Now, part of that right is Congress came back and said, well, it's not enough just to give them a right to join and help a union, but they need to be able to have the time to help the union and represent the union. Here's the reason why. Bad acting agencies will do all they can to prevent representation because it will prevent accountability. The only reason an agency will ever try to prevent, restrict, manipulate, miscalculate, whatever in dealing with official time, I can promise you, you are dealing with an agency that has an anti-union or a union animus agenda. There's no doubt in my mind. Why? Because official time has been enshrined in the federal law and then has been further agreed to in our collective bargaining agreement. And once that time has been enshrined and agreed to through the contract and given to the union, it is not the agency's place to come in and say, we want to further restrict how you use that time, who can use the time, how much of the time they can get. That is not up to the agency. And we're going to go through that as we go through this collective bargaining agreement. And I'm going to share with you the discussions we were having both locally and nationally, so to the point that I challenged the agency and prevailed. And I'm going to share that with you as we go through this agreement, okay? But the first thing the article says under the purpose is that official time as a necessary, get it, as a necessary part of collective bargaining and related activity is in the public interest. The contract has already said official time is a necessary part of collective bargaining and related activities in the public's interest. That means that not only did the statutory law give it to you, but the contract also says it's given for those specific reasons. The next sentence is very important. And it says the parties recognize. When it says parties, it's talking about the Department of Veteran Affairs, VA Central Office, all the way down to your local field station or your local field agency, and the department and AF and American Federation of Government Employees. From our national union all the way down to our local shop steward, our local unions, the parties recognize that good communication are vital to what? To positive and constructive relationships before the union, or between the union and the department. I can tell you this. I can tell you how well your agency works with the union and how well the agency works with the bargaining unit by whether or not they have good communications or not. When you don't have good communications, the only communications that you're going to have are going to be contentious, for one, and then two, without good communications, you're going to have a huge array of unfair labor practices. Why? Because the agency does not engage in good communications. They don't believe that they're vital. And you're also going to have a lot of litigation. Why? Because the agency doesn't believe that good communications are vital to a positive and constructive relationship. I can only speak for the agency that I work at, okay? And I'm going to share this with you because what I'm going to share with you about communications is something I don't ever want any of your locals to ever go through. So what I'm going to share with you will be the extreme. What I'm going to share with you is going to be what is an outlier in the collective bargaining agreement as it relates to good communication between the union and the department. Okay? The next sentence says, these communications, what communications? Good communications. It's saying these good communications should facilitate and encourage amicable settlement of disputes between the employees and the department involving conditions of employment. If you've got good communications, you're going to be able to resolve issues without having to file a grievance or without having to file an unfair labor practice in the most cases. I would say that an agency and union that has good communications may file grievances 5 to maybe 10% of the time. Agencies and unions that do not have good communications, it's going to be just the opposite. At my local agency, I've been a union steward for about 20 years. And I was a union steward under the old contract, which was the blue one, the blue book. And I'm also have been a union steward or representative under the new contract, which was the green book. From 2003 to about 2016, our union may have had 10 grievances total, 10 grievances total over that 13-year period. And I believe we had 1 or 2 arbitrations in that time frame. Why was the arbitrations at a minimal? Why were the grievances at a minimal? That is because the parties recognized that good communications were positive and constructive in settling disputes between the employees and the department. So we spoke on a first name basis. We had each other's cell phone numbers. We communicated before work. We communicated after work. We had gentlemen's agreements where we shook hands and we understood each other's position and each other's side, and we respected it. But because we had good communications, we had very, very few grievances and almost no arbitrations, at least during that 13-year period, from about 2003 or year 2003 up to about 2016. Okay, very few. So that's why you have to have good communications. It is incumbent upon the agency to ensure that good communication happens. When you go back and look at the master agreement, after Articles 1 and after Article 2, you get into Articles 3, 4, 5, and 6. Okay? And maybe even Article 7. And those articles deal with, Article 7. Those articles deal with labor, management, collaboration. Most agencies that do not have good communications in Article number 48 do not have good communications through Articles 3, 4, 5, 6, and 7. Because those articles set up and establish good labor management collaboration, good labor management cooperation, and good labor management friendship and relationships. Article 48 is only a consequence of the violations of Articles 1 through 7. Articles 1 through 7, okay? When agencies don't comply with Article 48, it's because they don't comply with the first 7 articles of the collective bargaining agreement, which means everything else after Article 7, as far as the agency is concerned, is just toilet paper. It's not a big deal. I don't have to listen to it. I don't have to do any of that. That's when you run into terrible communication problems, okay? Now, let's go to the next paragraph. The next paragraph says, as provided in 5 U.S.C. 7131, official time shall be granted as specified in law, and in any additional amount the department and the union agree to be reasonable, necessary, and in the public interest. Now, 5 U.S.C. 7131 guarantees official time. Period. It guarantees official time. If any agency ever says to you as a union or employees that the union has ran out of official time, they are telling you a bold-faced lie. The union, according to federal statute and our collective bargaining agreement, never, ever runs out of official time. When an agency says the union has exhausted its official time, the agency is saying the employees have lost their right to union representation. Employees never, ever lose their right to union representation. I don't care how much official time is in the contract. Statutory law says, and federal law says, no employee shall ever be denied a right to union representation. And how does that representation how is it performed? Through official time. So no union ever, never, ever, 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 never, ever exhaust or run out of official time. I told you I was going to give you the extreme of the spectrum and an outlier. The John J. Pershing VA Medical Center in Poplar Bluff, Missouri is that outlier. We are the third smallest VA in the nation, third smallest, and we have more litigation than the 10 biggest VAs combined. VAs like Houston, Texas, San Antonio, Texas, Seattle, Washington. We have more litigation than the top 10 VAs put together. Our VA has a total, including managers, of about 1,200 employees. Total, maximum. Big VAs, some of the biggest VAs, have anywhere from 4,000 to 6,000 employees or 7,000 to 8,000 positions throughout their organizations. So when the third smallest VA in the country has more litigation than the top VAs, they've got poor communication. When the third smallest VA in the nation has more confirmed and sustained unfair labor practices than the top 10 VAs in the nation, that means you have poor communication that does not result in attempts to resolve disputes. So this is important if you're going to have good communications that works where? In the public's interest. When you don't have good communication, the taxpayers, the general public, bears the brunt of poor communication. Recently, our agency has terminated a young man by the name of Scotty White because they refused to listen to sound, reasonable communication. That young man was illegally terminated. He was denied a reasonable accommodation and has just been returned back to duty through an arbitrator's decision that has also gone through the appeal process. And because of that decision, the agency has to pay this guy almost $450,000 in back pay, pecuniary, and non-pecuniary damages for, why? Because of poor communication. The agency made up in their mind when our medical center director got disciplined and was under investigation starting in 2016, they were not going to have any more good communications with the local union. We got a new medical center director in January of 2016, and I shared with her when she came on board, I said, Patricia, you need to be careful. You've got some managers underneath you that are spiteful, they are manipulative, and you need to not allow them to push you out on a limb and saw it off behind you. Those were my exact words to her within our first 30 days of coming to the agency. Within 90 days of coming to the agency, because she wouldn't listen to good communication, she and her human resources ERLR, Corey Jensen, and Dr. Krishnan were under investigation for whistleblower retaliation because we tried to help them through good communication avoid that issue. Once they began to go under investigation in 2016, all communication with the agency turned sour. The union kept moving forward. We kept trying to have good communications. We notified the VA Central Office in 2016 early. We notified our National VA Council that we were having some communication issues because the agency had really just shut down and says, we don't respect the union, we're not going to hear anything about you, we don't want to talk to you, we're going to do our things our own way. And because of that nationwide dispute involving a whistleblower that went nationwide, the agency became retaliatory and began to attack the official time. And they did not agree that anything was reasonable in dealing with the union or representation. They did not believe anything was necessary in the handling of grievances and complaints. They didn't agree that anything was in the public's best interest to resolve issues at the lowest level. or to protect taxpayer money. They didn't believe in any of that. And as a result of just that one bad decision for that one employee, the agency's got to pay out in wages, back pay, almost $600,000 in attorney fees from one bad decision. When you have one bad decision, you can bet where there's smoke, there's fire. And fire was all around this agency when it came to official time. All right? So these are the issues that we really want you to be abreast of. And I'm giving you the far extreme. And once again, I hope your agency or your local never has to go through this at all. But our agency violated Article 28 as much and often as they could. Okay? Let's go to the next section. That was section 1. We're now in section 2. Section 2 deals with the designation of union officials / representatives. Some of section 2, not all, some of section 2 deals with national offices. The National VA Council President, the 3 executives, the National Treasurer, the 15 National District Representatives, 12 appointed national reps, and 5 appointed health and safety representatives. Those are national figures that's given X amount of official time that has been what? Agreed to through what? Good communication, good negotiations, to be necessary, reasonable, and in the public's interest. This is what both parties agreed to as being necessary, reasonable, and in the public's best interest. Okay? That's the national people. Now, as we go to the next section in this article, I believe it's section C or B. It says when VA central office will work with the local facilities. B, when the union assigns individuals, representatives, who are not subject to a national or local 100% official time allocation to participate on a national task force or a national committee, the department will afford such individuals official time for preparation, travel, and participation related to such assignment. Once again, this is dealing with individuals who are not a national representative and who are not on 100% local official time to participate on what? A national task force or a national committee. The department will afford those individuals official time for preparation, travel, and participation related to such an assignment. Okay? That kind of deals with some of your national time as well. All right? And it also says that this time will come from the bank of hours described below if the employee is not otherwise on 100% official time. Look at that again. This time will come from the bank of hours described below in upcoming sections if the employee is not otherwise on 100% official time. Should the bank of hours become unavailable, the department will authorize the time to participate. Okay? So you really need to dig into this part of the article and really understand what it's saying and what it's not saying. Okay? Let's go to the next section. Let's go to paragraph F. Paragraph F does not specify what type of union official. Paragraph F on page 246 says, when union officials visit a facility other than where they are employed for the purpose of engaging in what? Representational activities, they will notify the department prior to their visit. The department will notify the union of any scheduling problems connected with the visit, and the parties will attempt to work out a suitable arrangement. Let me say it to you again. That section does not specify national representatives or national officials. That section says when union officials visit for what? Representational activities. What are representational activities? Grievances, arbitrations, UOPs, bargaining collectively, representation, teaching, training, instructing, providing guidance. All of that is entailed in representational activities. Okay? Section 48, Article 48, Section 1, I believe it is. Oh, Section 2, Paragraph F. Now, I'm not going to deal with Section 3 because it deals with national representatives. And I'm not going to deal with Section 4 because it also deals with national representatives. Well, let's go to section number 5. Okay? Travel to other locations. Once official time is authorized for a specific function that requires travel outside of a union representative's duty station for a specific function that requires travel outside a union representative's duty station, the representatives will be permitted to leave the facility to discharge their functions after what? Notifying their respective supervisor of their destination, expected return date and time, and the category of representational activity involved. The categories are negotiation of a term collective bargaining agreement. That's the big national team. Negotiating changes to conditions of employment. That does not have to be national negotiation. It just says negotiations. Dispute resolution and/or general labor management relations. Okay? Pretty simple. Nothing hard about that, okay, to figure out. And it also says in paragraph B, when travel to another location within the jurisdiction of your local is necessary for representational activities consistent with the provisions of this agreement, and the transportation is otherwise being provided to that location for official business, the union will be allowed access to transportation on a space available basis and also authorize official time for travel. Okay? So you have paragraph 1, a section 1, and then you have a section 2. All right, that's very important. Here's why. Some of us are representatives that help unions across the nation. We help unions with grievances. We help unions with arbitrations. We help unions with bargaining. We help other members. Our agency, right after this contract was put into place, had agreed that official time from our local would be agreed to be utilized for us to travel back and forth across the country to help other locals. And since 2012, 2013, I want to say 2012, maybe early 2013, that is exactly what happened. We worked with locals across the nation. I've worked with locals in Arkansas, Kansas, Illinois, Washington, Tennessee, you name it. I've helped locals across the nation. And that time was agreed to, authorized, and all I had to do was tell my supervisor where I was going, when I was coming back, and what I was going for. And we moved on down the road. No issues, no problems, no concerns. We just moved on down the road. Why? Was that agreed to and not an issue? Back to section 1. Because we had good communications, we had good respect, and we had a good working relationship, and we didn't have them issues to be concerned with. And we have not had them issues to be concerned with for over 10 years. Okay? So let's go to the next section that we're going to discuss here. Section 6. Section 6 says there are other activities that utilizes official time. And it tells us how the official time will be calculated, how it will be captured, things of that nature. Other activities, remember this is still representational activities. Representation is not just sitting with an employee for a counseling. It is not just sitting with an employee when the agency wants to issue a proposal of action against the employee. Admonishment, reprimand. That is not the only form of representation that occurs. To be honest with you, that is the smallest amount of representation that has to occur. It's things of that nature. Why? If you have good communications, you will not need a lot of that type of representation. Why? Because you have a good working relationship. But this one, this part of the contract says, employees will be given official time to handle labor management committee forms, quality management, a quality program, and that could be a quality program that covers any wide range of areas. If it improves quality and it's a program, it qualifies for underneath here. And it says in the next sentence, this official time. What official time? All activities related to LMC or LMF and a quality program will be official time, will not be counted against allocated official time as described in this agreement. So that means that employees or union reps who attend LMF, LMCs, engage in quality programs, they will do it on official time, but that official time will not be counted against the union's bank of hours. It will not come from that formula we're going to talk about in just a moment. Okay? Now, the contract also says that a union official does not say national representative. It says union official, that means from the top to the lowest, who is designated as an employee's personal representative. So you can have a personal representative that is not a union rep or union official, and you can have a personal representative that is a union official. Either way it goes, if they are representing that employee's personal or being an employee's personal representative, their time will be duty time. When preparing or presenting appeals to Merit System Protection Board and handling claims under EEOC, Equal Opportunity. So what that says is, if I'm going to represent James Brown, and James Brown has the EEO complaint, or we're preparing for a Merit System Protection Board case, I'm going to be utilizing duty time to do that. Here's an example. I'm 100% official time. My duties consist of being on 100% official time 8 hours of the day. If I'm going to help an employee as a personal representative, because I cannot represent them as a union through EEO, and I cannot help them as a union through Merit System Protection Board, anytime I spend helping that employee under that scenario is duty time. It is not official time. So I take my time that I spend here and I put it back into my bank of hours to be utilized by another representative or be utilized in the future. Why? Because I'm representing a MSPB case or a EEO claim on duty time. That's very, very important. Some of you, I probably guess that you are helping employees with MSPB cases and you're helping employees with EEO complaints and you're doing it on official time. Please stop. If you are, stop doing that immediately. And I can help you and teach you how you track your time, okay? This is important for you to know this. Because the only person that tracks official time by law and by contract is union representatives. The agency doesn't track your time. They don't record your time. You don't get approval to use your time if you're on allocated official time. The union representative is the only one that will track that time. And I need to show you in the future, I didn't think about it in doing this presentation, but there is a tracking sheet that we utilize at our local. And we use that tracking sheet. It is an Excel spreadsheet, and it has on there all the activities listed on the Excel spreadsheet of what does not constitute official time. It'll have vacation or sick leave. It'll have FLRA, Federal Labor Relations Authority. One column would be for MSPB and EEO. One column would be for bargaining, collective bargaining. One column might be for 7131 time, when the agency calls a meeting. Part of them, one column will be 7114A2A. So what I'm going to do is, when I post this video and send it out to the body, I'm going to include in the email an example of how we track our official time. And you can contact me for help and assistance. And my name is Kevin, Kevin, Ellis. And I can be contacted through a couple of ways. One, cell phone, 573-429-9030. Or you can email me at kevin.ellis@va.gov. Official time. That time utilized will not adversely affect the employee's performance appraisal. Okay? Employees who do 50% official time or maybe 25%, the agency will not hold that protected activity against that employee. It's illegal. You cannot do it. Okay? You just simply cannot do it, period. All right. Let's go to the next section. I'm highlighting Section 8 for a specific reason, because this needs to be kind of explained. The union may substitute a retired VA employee for one of its national reps or national LMR for meetings. That deals with your national people, okay? And it just says that the department will provide travel and per diem in advance for any retired employee that's dealing with national labels as part of national LMR. Just pretty simple, pretty easy to understand. All right? Section 9, allegations of abuse. You're only going to have an agency ever raise an alleged abuse of official time by agencies who fight against official time. Agencies who don't have good communications, who don't have a good working relationship, you're bound to have somebody from your agency or your vision make an outlandish claim that official time has been abused. At our local agency, in my 20 years of being a representative, the only person that has abused official time in my 20 years of being a representative is the agency. And I make that claim because we've had 3 arbitrator decisions. Arbitrator Kist, Dennis Kist, Arbitrator George Elman, and Arbitrator John Remington. All 3 arbitrators arbitrated 3 different arbitration cases involving official time. All accused the agency of lying about official time, manipulating official time, stealing official time, miscalculating official time, all for the purpose of denying the union the right to utilize the official time. So very rarely will you ever have union representatives abusing official time. At our agency, it has only been the agency. And 3 arbitrators have made that decision at 3 different arbitrations. The 3 arbitrators did not know each other. did not speak to one another, and all three from different states, and all came up with the same conclusion. The agency abused the time, and they were untruthful or lacked candor, or their testimony in dealing with the official time was what? Not credible. That means what they were saying about official time as an agency was not true. It was false. And arbitrators picked up on it, they knew it, and we provided evidence to show that, okay? All right, let's get to the next section. This is a big one. Section 10. This is where the rubber meets the road. This is very important for locals to know, okay? And I covered a little bit of this in my presentation of Articles 1 and 2, and I said I would deal with it more when we got to Article 48. Let's deal with it right now. Section 10, paragraph A says, every local union will receive an allotment of hours equal to 4.25 hours per year for what? Each bargaining unit position represented by that local union. Here's why that's important. From 2018 through 2022 and through May of 2022, from March of 2018 through May of 2022, our local agency, the John J. Pershing VA Medical Center, was using VATOS to calculate official time. And they were calculating official time by the 4.25 formula per year for every bargaining unit employee. You heard me correctly. They were trying to say official time is granted only for 4.25 hours for every bargaining unit employee. They completely blackened out the word position. They did that on purpose. Here's the reason why. Our local agency, from 2018 through May of 2022, kept making a false allegation the union has exhausted their official time. And they counted us AWOL when we represented employees. They counted us leave without pay. They tried to issue us disciplinary actions. Why? Because they purposely tried to allot official time based on 4.25 hours per bargaining unit employee. They further went on to say that if where a local represents an employee at a CBOC greater than 50 miles, the local union, and they tried to say the local union at the CBOC, the union at your facility only has one local. They don't have a local at the main house and then a different local at each of your CBOXs. They do not. They've got one local and one local only. Ours is local 2338. And we've got 6 community-based outpatient clinics, or CBOXs. We got 6 of them that are more than 50 miles away. 25% time is given for the CBOC as well. That's in addition to the 4.25 hours per year for each bargaining unit position. That is a addition to. Also, pay attention here. Each VHA, Veterans Health Administration, and VBA local is entitled to a what? Minimum of 50% official time. That simply means this. Irregardless of the 4.25 hours, at a minimum, every single local is entitled to a minimum of 50% official time per year. Remember earlier when I said to you that the union never, ever runs out of official time? This also verifies And the agency and the national unions and national agency agreed there is a minimum of 50% official time irregardless of the formula. The formula gives you more than 50%. It gives you, it entitles you to more because the national parties, the VA and the union, both agreed to 4.25 hours per year per bargaining unit position. We recently learned we had 1,115 bargaining unit positions. The agency was saying we only had 800 employees, or 800 butts in the seat is what they were saying. So they were taking 315 or so positions out of the contract and saying we're only going to give you time by the formula based on butts in the seat or bargaining unit employees. The contract is very clear. We challenged the agency on that. We took it to arbitration, and here's what the arbitrator said. 50% of my official time does not come from the allocated bank of hours. The 4.25 hours per bargaining unit position at our local is about 4,000 hours per year, somewhere in the ballpark. Just a rough number, 1,100, 4,000, 4.25 is over 4,000 hours. 50% of my time, which I'm 100%, so 1,040 hours of my time is irrespective of the formula. So 50% of my time is free time at a minimum, irrespective of the count. Okay? Secondly, the arbitrator also said the 25% time is allocated to the local union. It's given to the union. So we got 6 C boxes. Between them 6 C boxes at 25% time, that gives us another count the hours of 520 hours per. I think it's 3,040 hours for each of our C boxes. That's added to the 4.25 formula, which gives us about 7,000 hours total for the year, each year. Why? Because 4.25 formula for the position, 50% is the minimum of 100% official, so 1,040 hours comes back out. It's free time, plus however many C boxes you have right here. Okay? That we challenged that. We were told that was not the correct interpretation. We took it before an arbitrator. He agreed with us. The agency appealed it. The FLRA says nope. We agree with the arbitrator. He interpreted your contract correctly. Okay? I've got that decision. If any of you want it, ask me for it. I'll share it with you. But he agreed with our interpretation of 4.25, bargaining unit position, a minimum of 50%, and a minimum of 25% official time at a CBOC. It can be more than 25% official time because you have a CBOC. But at a minimum, it's 25%, which is 520 hours per year. Okay? So when an agency tells you, or try to tell you that's not the interpretation of the formula, contact me, Kevin Ellis, ask me to give you my arbitrator decision, and I'll give it to you and send it to you. We can put that argument to rest, okay? All right, the last part I want to cover here is this. Let's go to paragraph D. Now, on paragraph C, 2 things is important here. The contract says that the calculation period will be done every 6 months after the agreement is in effect. The agreement came in effect in March of 2011. Every 6 months, September and back to March, the agency is required to give you your bargaining unit position count, because that's what the formula is based off of, bargaining unit positions. And each year, you get to recalculate what your official time is going to be. Each year. that time will more than likely always go up because agencies are always adding new positions to the agency. They get funded for them. They're always adding new positions. In September of last year, we were told that we had 1,150 bargaining unit positions. We learned last week, since September 2022, we have 1,160 positions, which means we've grown 45 positions, and take 45 times 4.25, that's the amount of additional hours that we have to go into our bank of hours, okay? That's very important. Now, paragraph D is also very, very important. Why? Remember when I told you the union never runs out of official time? The statutory law, 7131, gives us official time. The contract gives us a formula, and then a minimum of 50% official time at a minimum. Paragraph D comes back and reconfirms all of that. And what does it say? The minimum, listen to that word, the minimum amounts of official time described in paragraph A, let's go back to paragraph A, which is a 4.25, and the minimum of 25% for the C boxes, that is the minimum amount of official time. Paragraph A in this section are not intended to limit the amount of official time that can be negotiated by the parties locally. So with paragraph D, paragraph A of section 10, and 5 U.S.C. 7131, the union never, ever, ever runs out of official time. Never. Once again, thank you for your time. Thank you for your attention. This was about a 52 or 53 minute video about official time, but I felt like it was important for all of us to be on what? One accord. Our logo is out of many comes one. All of us should be speaking across the nation, from little local, little VA to big VA. We should all be speaking with one voice as it pertains to Article 48 and official time. One voice. Why? The agency speaks with one voice across the country. The union should be speaking with one voice also across the nation, in our districts, in our councils, and in our locals. If we do that, you will find a greater level of success and a greater level of achievement. Once again, my name is Kevin Ellis. My number is 573-429-9030. I represent Local 2338 at the John J. Pershing VA Medical Center. And you can reach me by email at Kevin, Kevin, .ellis@va.gov, or my personal email address, KCE40, Kevin as in K, C as in cat, E as in Edward, the number 40 at yahoo.com. Once again, God bless you. I love you, and you'll hear more from me in the coming weeks and months. My next one will be Article 17, Employee Rights. God bless you.